today, so I have a probably close to those who are able to make it. So I think we'll go ahead and get started. I am going to be chairing this meeting. You haven't been hearing me talk this much in the meetings before, but Justice Duncan needs to step back from being quite as active in the work of the work group due to time constraints. And so you're going to be hearing more from me. I heard an echo there, but I think we're good now. And so we have quite an agenda here today, and are there still hearing feedback? Jim, are you able to mute your phone? I think that might be the issue. But we're going to get started on our agenda, and first of all, I think that Amy's got some general announcements about the Law Commission to make.
I do. Hold on just a second. I've got people still coming in, so I apologize if I jump back and forth. The Law Commission, I think we were going to talk just briefly about the website and the recordings. I'm going to have those recordings posted, should be end of the day today or tomorrow, so that you can go back and instead of scrolling through emails and looking for those old recordings, they'll all be posted on the website. And so you'll be able to see the May 15th one, which we didn't send out on Friday, and this meeting, and they will be available to you all. So if you want to listen to the conversations you all have been having back to 2020, they will be posted publicly. So thank you. Was there something else, Krista? I think that was what I remembered.
I think that's what I had on my notes.
Okay.
So today we're gonna be trying to get through some of these remaining decisions that really need to be made in order for Legislative Council, mainly Jessica, to be able to get our draft really in order, getting it to where the position is that we need to be to actually present it to the legislature. And we have some fairly significant decisions left to make here. And in order to get there, we're going to try doing some polling during our meeting today to just kind of get the sense of, it's not a vote, so don't be worried that this is a vote, but just to try to get a sense of where people are at on some of these things so that we have a way of seeing where we need to keep working to move things forward. So if you have any questions about what we're doing as we are doing it, just let me know. But it's not intended to be anything formal. We're just trying to gauge where our sticking points still are so that we can figure out what the work is that needs to be done in the very near future. And the other thing I just up front want to announce is that we would planning to send out after this meeting a list of additional questions or questions that we think we know the answer to. And so we're not presenting them during the meeting, but we'll send out a list. And if you disagree with what we think we're doing, then just send us a written response to let us know. But otherwise, those questions with the proposed answers will be incorporated into the draft that Jessica is working on. And again, it's not a final draft. It's just the draft that we'll be able to work off of a more final draft, I guess. So with that note, I think it would be good to start with our first question on the outstanding questions list, unless which is Jessica, unless anybody has any opening questions that you want to ask as far as clarifications here about what we're doing today. Okay, Jessica, do you want to take it away on the first question on our list?
Sure. So the first question has been talked about a little bit, and that is, are we going to have one set of statutes that is going to be applicable to both municipal courts and justice courts? and then separate sections for, small claims and civil matters and justice courts and other statutes that will be applicable only for municipal courts? Or are we going to keep these things completely separate, as they mostly are under current law? And the proposed answer is that we do keep things separate. Before I jump into why my reasoning is for that, I wanted to very, very quickly cover our codification process, just a really quick explanation. So we codify new statutes at the end of a long session. So if this bill were to pass in the 2025 session, that would occur in August through November of 2025. And that is when we are assigning numbers to new statutes. We're deciding where they're going to be codified. We can create new chapters. We can move things around. We can renumber. Generally, the decision as to where these statutes will be codified will be made at that time with the input of the group. There are some exceptions for that. If something needs to be added to a series or a chapter for a specific reason, like it needs to pick up a definition, then we can put something into the bill that says, section 1 of this 2025 Act is added to and made a part of, ORS chapter, whatever. We don't do that for purely editorial reasons, meaning we don't do that when we just want to force codification into a certain chapter. We only do that when there's a specific reason, such as picking up a definition. The one caveat is that some of the statutes that we're working with now have already been added to or made a part of a chapter or a series. So looking ahead, we would need to make that decision as to where things would go, at least pertaining to the statutes in chapter 221. And there's a couple of other random ones where we would actually need to unadd them via this bill and then decide where they go in 2025. I'll also say that mass renumbering or renumbering generally is extremely time consuming and labor intensive. And so we can definitely do it during codification, but it should be for a deliberate, intentional reason. So turning to the question of whether these should be separate statutes or merged, I think it makes sense to have all of the justice court provisions, which are now scattered between chapters 51 to 55, 156 and 157, to all be in one place in Title VI. So our work draft, the current version basically gets rid of chapter 157. And I think the thought is that probably chapter 156 is just criminal procedure and justice courts could be moved into Title VI, whether that's creating a new chapter or not. So that would have the benefit of having all the justice court provisions kind of not exactly in one place, but in similar chapters. Right now, as you know, chapter 221 has the municipal court provisions, and that chapter is generally about cities, and it also contains the provisions that authorize a city to establish a municipal court. To me, it doesn't quite make sense to move all of the municipal court statutes to Title VI, and mainly just because chapter 221 is generally about cities, and it seems to be a logical place for that. So I would propose moving everything in justice courts and having all the justice court provisions somewhere between chapter 51 and chapter 55, having all of the municipal court provisions, including appeals, in chapter 221. So for most cases, everything pertaining to those courts could be found in those two separate places. And the other benefit of having this bill is right now, chapter 221 does reference justice courts and kind of points you outside of the chapter, but we would be adopting our own statutes pertaining to municipal courts. So most of the procedures that you would need would be in chapter 221. I realize that there's going to be significant overlap between the two courts with some procedures, but I think that they are separate enough and their jurisdiction is separate enough that it warrants codifying them in two different places. So that's the proposal on the table right now.
So I think what we'd like to do is do a poll on this at this point and see if people have any substantial concerns about it, and maybe This is a little bit awkward, I guess. The question is, should we talk about any concerns beforehand? Perhaps in this case, it makes sense to do. So what concerns do people, if any? Heather.
I just had a clarifying question. If I understand the proposal correctly, it sounds like the two chapters would basically mirror one another. It's not so much a substantive difference as it is like where you'd find the procedures. Is that correct? So chapter 221 would contain the municipal procedures. And what we've been discussing so far with respect to those procedures, it sounds like they'll basically be replicated there.
That's right, with the references changed as needed. Yes.
Judge Cross.
I think having them separate is important. I think that's the right thing to do. My only concern is with the we got a little bit of lack of definition in terms of a new chapter for appeals from justice courts. I think collecting the appeals into one chapter is absolutely fine from my perspective. I would imagine that it might be better though we have an appeals chapter in chapter 53. And perhaps I know that says appeals and civil actions. I think we could simply change that to appeals and justice court actions, and then make sure we delineate all the different types of appeals we're talking about with the particular statutes. I think that might be the way to achieve that. I couldn't hear that.
I think Emily's had her audio on by accident. I muted her.
Oh, okay. So, anyhow, I think that would be the way to avoid having to do an entire new chapter. Then we simply would move some statutes as amended to that chapter. That might achieve the goal in an easier way. Still not easy, but easier.
If I could just ask a clarifying question. So do you mean keep the statutes in 221 that have to do with the establishment of the municipal court jurisdiction in 221?
Yes.
But all the appeals provisions would be moved to parallel
just the justice court ones.
Oh, okay. Got it.
Because we're talking about because of the proposed answer was for a new chapter for appeals from justice courts. I don't think we need a new chapter. I think we can put it in the appeals chapter that currently exists.
Yeah, I agree. There are some current chapters that have room in them if we needed to use them. So yeah, when I say new chapter, I guess I'm just saying moving them all, like 156 and 157 would no longer exist. They would be moved in somewhere between 51 and 55.
Right. Now, and I think we're talking just moving them. If we start talking about repealing portions of those, that's an entirely different question. But in terms of moving them, I don't have a problem with having it all in one spot. Judge Brisbane, what do you think?
Okay, I agree that the justice court statutes should ideally be in the same location. 156 and 157 have really, in some cases, very antiquated language. And if we move those over without making changes, and I don't know if this work group has the ability to go that far, because we're supposed to be working on appeals. And there are a lot of other things in 156 and 157 that need updating. I don't know if you want to do that, but they should all be in the same. I agree with you. They should all be in the same place. And I also agree that municipal court and justice court should have separate statutes. Leave the municipal courts where they are in 221.
Just to be clear, chapter 157, the provisions of the work draft would completely replace the contents of 157.
Okay.
As for 156, I think there are some conforming amendments, but we haven't really focused on rewriting those because we're focused on appeals. So I'm not sure we would be able to do like a big update of the language, but we could at least consolidate everything in one place.
I'm pretty sure that some of those statutes might be from 1800, where you had your trial the next, the statute requires you to hold the trial the next day. This is like when somebody stole your horse or something, you could bring it before the justice of the peace and the trial would be the next day. I mean, those are some of the things that are in those 2 chapters that need work.
But that is definitely going to be beyond the scope of what we can do in this legislative session. I'll just say that. And this work group was created to address the appeals. If there are other things that people want to address after this, that can be a different discussion. But keep your own list, and maybe that can happen at some point in the future. Anybody else have clarifying? Yes, Jim.
My only concern is that my understanding is that ORS chapter 156 addresses violations regardless of whether they are heard in justice court, municipal court, or circuit court. Where that chapter is now in the title that it includes criminal cases is kind of a central point for all those courts to make reference to. If we move it into Title VI, that means that circuit courts and municipal courts will be looking at that title instead of the title having to do with criminal cases generally. I don't have a good solution for it. It's just a very awkward situation because it cuts across all 3 courts.
Are you talking about chapter 153?
No, I think 156, I think Jim's talking about.
Yeah.
Yeah.
I just don't see how chapter 156 has to do with violations in circuit courts, I guess.
I may be mistaken, so let me withdraw my comments until I have a chance to check that out.
I will just quickly say that chapter 156, I believe, has no legal series in it. So that just means that the decision as to where to put those statutes can occur. Like, we can make that decision up until codification time. We don't need to make that decision now. So happy to revisit that.
I think it's limited to justice courts. I mean, I could be wrong though, Jim, but I think that's what it is.
Oh,
So I think at this point, it would be good to move on to another question. And if people have ongoing questions about this one, the email lines are open. So bring them up after this, after you've had more of a chance to think about it. In general, what I am hearing is people support the general idea of having them codified in 2 different locations, one for municipal, one for justice. So I'd like to just take a quick hand poll on that. Is there anyone that is opposing that idea of codifying them in 2 different locations, one for justice and one for municipal courts? Anybody raise your hand? Okay. And if you do have further comments about that, please reach out to Jessica or to one of the chairs. Thanks. So let's move on to the next question, which is in section 9A, what fees will be charged? Which cases will have fees? What court will they be paid to? And how will they be waived or deferred? And the proposed answer, first of all, is that filing fees and trial fees will be maintained as in current law. And that's the proposed answer, just because it didn't seem like we had consensus on that in discussions. So what I'd like to do is use the polling to sort of get a sense at this point of where we're at on that. So I'd like to take a poll of agreement with the idea that filing fees and trial fees will be maintained as in current law. Would you raise your hand if you're generally thinking you're in support of that? Okay, so we have a lot of people that didn't raise their hand. Who is opposed to that idea? And there may be a different answer other than opposed. So who is opposed to that idea, first of all? Okay, I see 2, Jim and Heather. Okay, and so then I guess that the question will be whether there is a consensus agreement that can be reached regarding that. And I guess I should ask too, who does not have an opinion or is abstaining from this question? Okay, so did everyone vote in some way here? So it sounds like we have two that are opposed to that general idea. Jim, it looks like you want to say something.
Yeah, I'm not opposed to it. It's really a policy question that is governed by others. My only comment is that my recollection is that when we heard from the judges and from my own checking around with a few courts, I found virtually no circuit court that was actually charging the trial fee for violation cases. And I don't know why that is, because the statute is clear that a trial fee is due. But my understanding from the judges is that for whatever reason, circuit courts are not charging a trial fee, perhaps because in violation cases, there is no jury trial. From what I've been able to tell, the hearings in circuit court maybe last 15 minutes, a half hour. They're much like the hearings in justice or municipal court, and perhaps they don't feel justified charging a relatively large trial fee for such a de minimis hearing. Respecting the trial fee, the filing fee, it troubles me that for all other purposes, we treat violation cases as criminal cases. And generally, Oregon does not charge fees of any sort for criminal cases, but we single out violation cases to charge filing fees for. Connected with that, the cases that I looked at out of Marion County, I would say at least 70% of the time, courts were waiving the filing fees anyway. So I just wondered about especially the trial fee, I wonder whether we should have it, because it appears few, if any, courts are actually charging it. And just a question of philosophically, why are we charging filing fees for this one category of criminal case?
I thought I was unmuting, but I muted myself there. I see there are more hands raised, and I know that we could have more debate about this. I think the question at this point is, how can we come to a consensus on any change for this? So I think at this point, I'd just be looking for volunteers, and you don't have to volunteer right now, but after the fact, if you want to, if you're interested in coming up with a proposal that you think you can get people on board with, and you'd like to see this changed, then contact us about that. Or you can volunteer right now if you'd like to. I'll open the floor if anyone wants to raise their hand and say that they're interested in working coming to a consensus with folks about this. That's lovely. Otherwise, I think the issue is just that we need to keep moving forward here. So, yeah, Justice Duncan.
Krista, I just had a question, and maybe not even a question, but we've got the filing fee and the trial fee, and I'm wondering whether there's agreement about which fees due when, and if we want to make the bill clear about if there's both of these fees, is it only the filing fee that would be due when you submit your notice, and the trial fee would be something collected later? I don't know if that's clear in the current statute or what the practice is, but it seems like there should be clarity about which, if there's two fees, which is due when and where it's payable. So that's just something to watch for. I don't know that we've specified that.
Does anyone have any comment on whether that's unclear at this point?
At least in my county, we collect the fee. We collect both. I think it's $420 when you combine the filing fee and the trial fee. And Washington County Circuit Court requires us to collect that when we send, and send over all the paperwork in order for them to receive it and process it, unless the defendant goes and gets a fee waiver from the circuit court in advance of that. That's what Washington County does.
In Clackamas County, we collect the $283 filing fee. It goes with the file to circuit court. The circuit court in Clackamas County does not charge an additional trial fee.
So let me do just another real quick poll here. Is there anybody who would be opposed to eliminating trial fees? Because I think maybe that needs to be separated out from filing fees. Are there people that would be opposed to eliminating trial fees if the filing fees remained?
With a caveat, because I really think that in traffic violation issues, the appeal goes to the circuit court. They charge a trial fee for, they're hearing the case essentially. And what should happen if the conviction happens at the end of the circuit court, that circuit court should send it back to the justice court, and the fine should be collected in the justice court because the court has received a trial fee. If we take away the trial fee, then the court's gonna I'm sure will not be sending the matter back to the justice court for the collection of the fine. So that's the issue there, and maybe the decision may be that we don't care about that, but that's I think that's one. My point would be that the circuit court should not be keeping the violation fee when they received a trial fee to hear the de novo trial.
Hi, this is Emily. I'm sorry I can't turn my camera on. I am also in Washington County, and we don't collect the trial fee here, and we're still getting the checks back. So I wonder what the disconnect is there between your court, Dan, and my court, that the circuit court is treating them differently.
So it would be great if you two could have this conversation. And I'd like to move on at this point. So I guess anybody who's interested in resolving this issue, if you can, anybody want to raise your hand now to work on it, or you can contact us later.
As a prosecutor for the state, I generally don't really care about fines and fees. But in this case, there is a mechanism for the courts to consider a waiver of fees. So I don't see the problem in collecting of fees up front with a robust ability to for the courts to consider a waiver of those fees at a later date.
The problem is that's so much money to the average, poor client or a working person that I think it could chill their interest in going for the appeal. That's a concern I would have as just as a citizen and defense lawyer. At $400 and some, a lot of people say, well, I'm just going to skip it. And I don't think we should encourage people to do that. I like the idea of waiving, letting the circuit court decide on the trial fee, not collecting it at the muni court or at the muni or justice court level.
Okay, well, once again, we're going to need somebody to come up with a proposal that you think people can work with if we're going to change this. So I'm going to leave it there for now. We got to move on. The next thing is adding the clarification that if the case contains both a violation and a misdemeanor, it will be treated as a misdemeanor case for fee purposes. Does anyone object to that? Okay, we have unanimity here, it looks like. So we can move on. Yay, that one easy one. I'll take it. The next one is fees or fee waiver requests where they'll be filed. And the proposal is that they will be filed in the local court, the fees or fee waiver requests. And then they will be transferred to the circuit court, accompanied by the rest of the appeal package, which would include the notice of appeal, proof of service, and case record. And then the circuit court will make the decision on fee waiver requests. So I'd like to just first take that as a package. Who is opposed to that? And I can understand there could be ideas about better ways of doing it or whatever. But let's just start with who is opposed to that whole process package. Okay, then the next question is, does anyone want to propose that there should be an amendment to do it in a better way? Okay, so it sounds like we're in agreement on this unless I'm missing something. Judge Brisbane.
Okay, good morning or good afternoon. In Clackamas County, the court currently has circuit court make the decision on the waiver before the case is sent, because the local court is collecting the filing fee to send with the packet. So if the file goes over there, then circuit court's going to be responsible for collecting the filing fee. Is that what the process you're suggesting?
I think there'd be they have to, correct me if I'm wrong, but I think the defendant would have to either post the filing fee and or trial fee if that winds up being required, or would have to submit waiver requests, and the fee waiver request would be sent over to the circuit court for the circuit court to rule upon. And then depending upon that ruling is, it would either receive it and schedule dates, or they would send it back because they denied the fee waiver. I'm guessing.
Right, the jurisdiction, excuse me, because jurisdiction has transferred to the circuit court upon filing, it would be the circuit court making that decision about whether to waive the fee.
So when they file the fee waiver, even though the fee waiver has not been ruled upon, that's still going to count as the filing of the appeal and jurisdiction transfer?
And that's current law.
I'm just trying to make sure it's clear, all the steps. Yep. So that's
So
fine with me.
So the fee then would be collected by the circuit court, as I would understand it, because they're the ones that have the jurisdiction of the case at that point. If they deny the fee waiver, which I understand doesn't happen very often, so it's probably a pretty minimal effect.
And I'm happy with that, because at least that way our courts can help the defendant make sure they have that fee waiver paperwork and so on. And I think we can oftentimes be a better resource for those mechanics than the circuit court.
Any other comments on that?
Yeah, one thing we might want to make clear is that if the circuit court denies the motion to waive fees, the notice should go to the defendant. And I don't recall whether the circuit courts hang on to the materials or whether they send them back. They may send them back, and the defendant would have to refile them along with the filing fee. But what I want to make sure, what I think should not happen is that the paperwork go back to the justice or municipal court and put the burden on that court then to get back in touch with the defendant. I think once the paperwork goes over to the circuit court, the local court is out of it, and the circuit court deals directly with the defendant one way or the other.
Because if the circuit court denies the fee waiver, and then they essentially send it back to the defendant, then you're gonna have a problem with whether they can get timely filed and within the 30-day period. If they reject the fee waiver, then does that count as appeal having really been filed? If they send it all back and don't accept the appeal notice, what happens then? Timeline.
Wouldn't they just provide the opportunity to then pay the fee if the motion for a waiver is denied?
I assume that it would work in the same way that the circuit court does all other fee waivers, because they process these all the time. So they would have their processes for dealing with denials of fee waiver.
I'm just concerned about the timeline for the appeal and whether if that means the appeal hasn't been timely filed yet because the fee waiver was denied. That's my question, because I don't want a defendant to lose their appeal right because they have the fee waiver was rejected or denied by the circuit court, and then they don't get the fee filed and get it done before the 30-day period is run.
I think that because the circuit courts already have processes around fee waivers for any kind of case, that they'll have their process for that. And so it shouldn't be a question, I don't think.
We
Okay.
probably should find out from the circuit court how they actually handle that, because this is unique, because there's a 30-day deadline.
Okay, I see what you're saying as far as jurisdiction. So we need to be clear.
Right.
If jurisdiction, I think the, correct me if I'm, Justice Lincoln,
I
yeah.
think the jurisdiction is with when the notice is filed and
Yeah.
the payment of the fee and other things relate to the perfection, and we perhaps the perfection of the appeal, and we can perhaps make sure that, and that's, I think, in the current law. So we can just be clear that the payment, that the notice, to Judge Cross's point, that the notice is when the that when it's filed, that's when your time is measured. And then the payment is taken care of at the circuit court. If they deny, like Heather was saying, there's a process for them to interact with the defendant or the appellant and get the money. If they don't get the money, if the waiver is denied and then the defendant doesn't act on the opportunity to pay, then the appeal is not perfected. And the current law talks about what happens when it's not perfected. So that's simply good to hear.
So
I'm good
maybe
with
we
that.
can, maybe we can see how the draft looks when we get it and make sure at that point that there aren't other questions about how this is going to work. Does that make sense? It sounds like we're all in agreement in general, so it's just a matter of making sure the words match up. Okay, let's move on then to the next one, which is oh, we already talked about it. Maintaining current law that jurisdiction transfers to the circuit court upon filing of the notice of appeal in the local court. So I don't think there's any question about that. If anyone is opposed to that transfer of jurisdiction upon filing of the notice of appeal, raise your hand. Okay. So let's move on then to the third question. How will we account for the fact that an appellant may not be able to identify the adverse party or know where to send a notice of appeal for service? And the proposed answer is that the order or judgment should list the names and service addresses for all parties. So that would include identifying the state entity so that the appellee or appellant rather would know who to serve and where. And so I guess I'd like to just start with a poll. Who supports this this process idea? Okay, and who's opposed to it? Okay, comments from those opposed. We'll start with Jim.
Yeah, I'm not opposed to it, but my understanding is that most cases, the judgment is the back side of the citation form that the judge fills in and signs. Is that not true? Are most courts?
For traffic violations, that's yes, that's if it's a handwritten citation, it's on there. If it's like the grocery store long receipt citation, then we actually have that converted to a standard size page document, and it's on that. But so it's on the front of that because we essentially format it differently so it fits on one page. But yeah, it's on the actual citation, if you will.
Okay, well, my
But
court
you-
doesn't use that format. We have everything generated electronically. We're completely electronic and we don't use that paper form to fill out anything.
So it might require a new business process or form for some courts. Do folks see that as an issue? Or is it worth the new process in order to have this procedure in place?
One of my concerns is that my understanding is that as a percentage of the total number of cases that justice and municipal courts hear, there are very few appeals actually filed, maybe less than 1% of your cases in any given year. And I would be reluctant to impose a burdensome notice requirement for that small group of cases. Perhaps we could have the statute read that upon request by the defendant, the court shall provide the name and address of the person to be served.
I wouldn't have a problem with that. With regard to violation cases, and in small claims cases, the addresses are actually on the claim. And parties, they respond and file, and the parties have an obligation to update the court with a change of address if that occurs. So I don't think we need to put it on the judgment because it's already in the file, readily accessible to either party.
Heather?
Am I remembering correctly that Jim or this work group created a new notice of appeal form? Could this be something that's just generated or given to the party when they request that notice of appeal form?
It's on the form. It's on the form that Jim did. With regard to a violation, anyway, they've got the addresses like the top on page 1.
Well, the problem with the court filling out part of the notice of appeal would mean that you're risking your court clerk practicing law.
Or maybe not on the form itself, but just that it's generated when they provide that form. So that they're not printing this out every time to Jim's concern, but just if people intend to appeal.
It would be different depending on who the prosecutor is in the case, right? So it couldn't be a standard form for every single kind of case, if I understand correctly.
Right. I mean, yeah, the vision is that perhaps the state court administrator would prescribe a form set of instructions that would contain a blank for the state representative to be filled in, and the local court would then, when it printed those forms off, would fill in that form in the case of the justice court, the name and address of the district attorney, and for a municipal court, the court would fill in the name and address of the city attorney. And so if a party asked for the notice of appeal forms, the instructions accompanying that form would have that address there, which would be modified by each court.
So that would go to your proposal then, Jim, that upon request, the court shall provide the name and address of the party to be served.
Yes.
Okay, well, let's take a new poll. I mean, this is a new idea. We didn't have it presented. So again, not binding here. But how many people like that idea, Jim's idea, that upon request, the court shall provide the name and address, rather than the idea that it shall be provided always on the porter? Who prefers Jim's idea? Who prefers that it always be provided on the court's order? Okay, so we have a difference of opinion here. So who is interested in working with the different ideas and trying to figure it out? Because we've got to choose one way or the other. Any volunteers up front?
No.
Okay, Heather, Judge Cross. If anyone else wants to, can email us later. Okay, we're gonna move on. We still have a lot of things here. So the next section is about sections 16 and 17 of the working draft, which deal with, or don't yet deal with, a number of provisions about, number one, appealability of specific orders, And then number two, the scope of what decisions will be reviewed in each particular type of appeal. Like if there's a no contest plea appeal, then what is the scope of review for that? Whether they can, or restitution judgment, whether everything in the case then gets reviewed or just that one particular thing. And then third, whether to specify whether when the circuit court will retain or remand for further proceedings. So there's a number of things that need to be worked on in these sections, regardless of the answers to the broad questions. The first one has been discussed, is being discussed at length over the default judgment appeal question. There's we've got a number of people working behind the scenes to try to hash out a plan to address default judgments. And at this point, it appears there's significant disagreement on whether default judgments should be directly appealable, whether there should be only appeal from a set-aside denial of a default judgment, or whether to address it at all. And so I think at this point, we're going to continue to work on trying to come to a resolution for that. What I'd like to know today is just again, a straw poll of big picture. Do folks prefer that we continue to try to come up with a discrete plan for every kind of appealability of these specific orders, including defaults and everything else that's in section 16? Or do people prefer that we take out section 16, which would be new language, and find a way to incorporate the current law about appealability of judgments and not change anything that's in current law as far as appealability of which kinds of judgments are appealable? So just a question about what people's preference is at this point. Would you rather simply retain current law, whatever it means? And there's some appellate litigation going on at this point about default judgments. So retain current law, whatever it means, or try to come to a consensus about which judgments will be appealable. So first of all, retain current law, whatever it means. Whose preference is that? Okay, try to come to a consensus on things. And a number of people aren't voting, so I'm not sure if that means no preference or you are just waiting to see. But it looks to me like we have a split of opinion here, and so we're just going to keep working behind the scenes on this. I don't think we're not going to discuss it today because there's too much to talk about. And if anybody wants to be in on this small group discussion other than those that already are, email us and let us know. Okay, the second point on here, though, is different. The scope of what decisions will be reviewed in particular situations, such as if there's an appeal from a no contest plea, what can be reviewed in that context, or if there's an appeal from a restitution judgment. Do you either A, prefer to leave it up to the discretion of the circuit court as far as the scope of review in those sorts of situations, or B, specify for each of these in the statute what the scope of review is going to be? So who would prefer to just leave it general and allow the circuit court to decide the scope of review? And I guess, and if you can't vote on this, that's fine. But in general, who prefers to just leave it to the circuit court and not specify? Who prefers to specify what's going to happen in scope? A lot of people didn't vote. Okay, so discussion around this, comments? Justice Duncan?
I just had one, there's a lot of these different types of questions about whether particular orders are appealable. Is that And one of the things I thought that there might be consensus around is we know that you can have a de novo appeal from a no contest plea, but there was questions about whether you can appeal from a guilty plea, and I thought there was consensus that you could appeal from the no contest, that you would also be able to appeal from the guilty plea. So maybe possible to break that one out.
Right, I think there was consensus around that one.
I
That it
I
would
think
be
it was,
the same.
they should be treated the same. The question is, what would be appealable from those pleas? I mean, do you, if you plead guilty or no contest, can you just go and get a trial in the circuit court? Or are you limited to whether or not your plea was knowingly, intelligently, and voluntarily given?
Right, I think that's the question is, both guilty and no contest will be treated the same. What would it be? Is it going to be specified? We do have something in current law. So does that mean we should just retain what's in current law and treat them both the same? For that one?
Yeah, they should be the same. I get no problem with that. I'm just asking.
Jimmy?
Sure. So I think there are sort of two questions. One is what types of orders and judgments should you be allowed to appeal from? And then the second question is once we allow that type of appeal, what should happen in it? And if we are going to allow a particular type of appeal, I think we owe it to the circuit courts to tell them what to do with it, rather than just saying, okay, now you have an appeal from a guilty plea, you figure out, you tell us what to do, right? We should have an answer to that. And I think current law, as I read current law, it seems to give one answer for no contest pleas and one answer for guilty pleas and do a lot of other things irrationally and not provide any guidance to circuit courts. So I think this is an area where we really do need to provide some additional guidance. And circuit courts aren't getting a ton of these cases. They might have one in a decade. And so they're not going to know, oh, I have an appeal of this type of case. I know what to do with it. They're going to be looking at this for the first time. And if the statute we have doesn't give an answer to that, they're going to have a really hard time with it, I suspect.
Let me ask this. If we have a couple of volunteers to try to hash this out, is anyone opposed to trying to get a consensus around giving guidance on the specifics of the scope of what decisions will be reviewed in these particular situations? Okay, so it seems like Jimmy, are you volunteering to help out with that?
Sure.
Great. And anyone else want to volunteer for that right off the bat?
I will.
Oh, wonderful. And then whether to specify whether the circuit court will retain or remand after appeals for discrete things. Right now in current law, as I understand it, and as we have incorporated into draft section 14, circuit courts have discretion about what to do with cases once they've heard an appeal on something. Is that something people want to maintain, or do you want to specify? And I think that in thinking about this, one question is there may be many different factual situations in cases. Sometimes it may look like cases are going to bounce back and forth a lot between justice and circuit courts for multiple issues, and perhaps it would make more sense for a circuit court to retain a case in that situation. And so that's the sort of question of, if we specify too much what happens, then it may create problems in individual cases depending on the facts and circumstances of an individual case. What are folks' thoughts on that? Jimmy?
So in my view, it's almost always going to be more efficient for the circuit court once it gets the case to see it through to the conclusion, rather than sending it back to the justice court. I think that introduces a lot more procedure to the mix and ways for cases to be forgotten about or people to miss hearings. So that's one category of things. But also, once you're in the circuit court, I think the efficiency from having it done in a local court is probably already lost. And at this point, we just need to get done with the case and be done forever. And I think having the case stay in the circuit court is the best way to do that.
So that would probably counsel for leaving the discretion to the circuit court to decide?
I would say, well, here's the problem. I think if we contemplate remands, I think we need to have an additional set of procedures. The current statutes sort of suggest that circuit courts may be able to remand to justice courts, but we don't actually have any additional guidance on what should happen if that happens. So I think if we wanted to allow for remands, we'd want to provide more guidance to, okay, now it's remanded, now what happens? Can you go back to the circuit court? Those kinds of questions.
Jim?
My concern is that in the cases that I reviewed, the circuit court affirmed, and I would say about at least 50% of the time, the defendant failed to appear, and so the court affirmed. But even where the defendant appeared, overwhelmingly, the circuit court affirmed or also found the defendant guilty and imposed the exact same fine. And so what troubles me about that is that the revenue then flows to the circuit court rather than to the justice court or the municipal court. I would advocate considering that at least where the circuit court affirms the lower court, that it be simply an affirmance of the local court's judgment so that the judgment remains that of the local court. If there's a reversal, then I think either a reversal or modification, then I think it probably makes sense to leave it in the circuit court.
Okay, so we need some volunteers to think more about this. So I think, does this fall into what Jimmy and Justice Brisbane are already committed to working on, or do you not want to volunteer for this portion of it? Do others want to volunteer to look at that?
It sounds like I volunteered myself.
Awesome. Okay, and Judge Ross as well. Okay.
And I would volunteer as well.
I'm
Whether
fine
it's the
with
same or
it.
the
I'm
different,
fine
I don't
with-
know.
Yeah, all
Okay.
these can be considered together, I'm in.
And maybe we'll also reach out to our trial court administrator members and see if we could get someone from them on this, because they can provide their perspective on how this fee payment actually, how that works.
Okay, thank you very much. And we are just about out of time, and I'm sorry we didn't get to all of the questions that we have. So we do need to eventually get to the small claims questions, and I guess what we could try is sending this out in writing and requesting comments so that we can move forward, or we can try to address it at our next meeting. So I guess we will send something out to you. Any other questions or comments for the good of the order right now? Okay, I really appreciate your participation. We are going to try hard to get through this stuff by the end of the next meeting, because we are really pressed for time to make this happen for this session of the legislature. So thank you all very much, and we'll be in touch.